Good day, Crime Talk aficionados. We have one heck of a show for you today. First, does the unidentified DNA in the Bryan Kohberger matter? Well, does that raise reasonable doubt? Karen Reed jurors are speaking out. Sean P. Did he do it? Combs has some good testimony from a government witness. Another teacher goes down. This day in legal history. We have our quote of the day, which deals with juror misconduct. And our dumb criminal taunts the sheriff to arrest him. Sheriff says, challenge accepted. Who won? Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get started, let me remind you to go to CrimeTalkSearch.com. Sign up for that background subscription service today. Literally, you're going to be happy that you did it. And who knows, it could save your life. Remember, knowledge is power, ladies and gentlemen. And so when you go there and you sign up for that subscription, you are going to be able to do as many background searches as you desire on as many number of people that you desire. You're going to find out whether, first, they have a criminal history. You're going to find out their background. Are they married? Are they divorced? Do they have a criminal history? You're going to find out if they have multiple email addresses, multiple phone numbers, and you're going to be able to find out what their social media presence is. Think about this, ladies. If you do the search and you find out your spouse, your partner has all of these other email addresses that, funny, he doesn't tell you about. What could those be used for? I don't know. Buying various things on the internet, various dating sites, perhaps. I wonder how that could possibly work out. So go to CrimeTalkSearch.com, check it out, and check them out. You're going to be happy that you did. All right, let's go ahead and get to the docket today. It is Friday, June 20th. Can you believe June is almost over? It's the official first day of summer, and it is a scorcher here in Colorado, and I love it. I don't like cold. I don't like overcast. I like sun and heat. All right, let's get to it. First on the docket, Bryan Kohberger. Now, the unidentified male DNA profiles found at the crime scene in the Bryan Kohberger case, 2 inside the house and 1 on a glove outside, are significant pieces of evidence, even if the court does not permit the defense's alternate suspect theory. So I'm going to explain how the evidence could be used if the alternate suspect theory is not allowed, and whether it would directly impact the investigation in a formal, clear, and precise manner if requested. So let's give you a little bit of context here. All right. Now, the defense has sought in the Bryan Kohberger case to introduce evidence of unidentified male DNA profiles to support their argument other individuals may have been involved or present at the crime scene, potentially implicating alternate perpetrators. This strategy obviously is aimed to create reasonable doubt among the Kohberger's guilt. This strategy aims to create a reasonable doubt about Kohberger's guilt by suggesting that someone else could have committed the murders. However, Judge Stephen Hippler had required admissible evidence to support this theory, and the defense filed their motions back in late May. Now, there was a hearing on June 18th, just a couple of days ago. We brought that to you, but unfortunately, that particular portion of it, well, we weren't allowed to see it. But the court had noted in previous hearings, as well as the law, we've done a whole show on the alternate suspect law in Idaho there. And anyway, it emphasizes that mere speculation of an alternate suspect is insufficient. So if the court does not allow the alternate suspect theory, the defense would be restricted from explicitly arguing that these DNA profiles point to other perpetrators during the trial. However, the use of unidentified DNA evidence, if the alternate suspect theory is disallowed, I think still comes in, just not for that particular theory, but you get the same effect. So if the alternate suspect theory is not permitted, the unidentified male DNA profile could still be used and introduced and used at trial, but their application would be limited to the challenging the prosecution's case rather than directly implicating other suspects. How's that going to work? So challenging the completeness of the prosecution's narrative, their investigation, right? The defense can then argue that the presence of unidentified male DNA at the crime scene indicates gaps in the prosecution's investigation. For example, they might assert that the prosecution failed to fully explore all individuals who were present at or near the scene, thereby casting doubt on the thoroughness of the case against Bryan Kohberger. And by highlighting that the DNA profiles, the two inside the house and the one on the glove outside, do not match Kohberger, the defense could suggest that other unknown individuals were at the scene, which could weaken the prosecution's assertion, obviously, that Bryan Kohberger acted alone. Now, this approach would focus on creating reasonable doubt without explicitly naming an alternate suspect. You see that, how that works, ladies and gentlemen? Questioning the strength of the prosecution's DNA evidence is going to be critical as well. So the prosecution relies heavily on the DNA evidence linking Kohberger to a knife sheath found at the scene, right? Just like this one here. Now remember, Brian, I haven't lost this one since I picked it up right after boot camp in the summer of 1988. Got to hold on to your gear. They teach you that in the military. Anyway, like I said, so the prosecution relies heavily on linking Kohberger to the knife sheath found at the scene. Now, the defense could use the unidentified DNA profiles to argue that the crime scene was obviously complex with multiple sources of DNA, and that the prosecution's focus on Kohberger's DNA, well, may have been a little overly selective. For instance, the defense might question why the unidentified DNA profiles were not pursued as rigorously as Kohberger's, potentially pointing to investigative bias or tunnel vision in the investigation. This could also undermine the weight jurors give to the prosecution's DNA evidence. Now, the defense could introduce the unidentified DNA profiles to argue that the crime scene was contaminated or that it reflects a high-traffic environment. For example, a shared student house frequented by many individuals, for example. Not too implausible, is that? This could explain the presence of the unknown DNA without directly implicating other suspects, framing it as environmental noise rather than evidence or alternate perpetrators. Now, such an argument could be used to dilute the significance of any trace evidence, including Kohberger's DNA, by suggesting that the scene contained DNA from multiple unrelated individuals. Now, during cross-examination of forensic experts or investigators, the defense could also question why the unidentified DNA profiles were not entered into CODIS. That's the FBI DNA database, right? Most states, if you're convicted of a felony, you go into CODIS. A lot of states, if you get arrested, they take a DNA swab and it goes in to CODIS. What did that mean? Potentially the alternate suspect, the unidentified people that were there. Well, we know they don't have a criminal history, just like Bryan Kohberger didn't either up until this point. Anyway, so this obviously could be used to challenge the credibility of the prosecution's forensic analysis, or by highlighting limitations in the investigative process, such as the inability to identify the source of these profiles. So if Judge Hippler prohibits the alternate suspect theory, the defense obviously would be barred from explicitly arguing that the unidentified DNA profiles belong to another perpetrator. However, presenting speculative scenarios about who else might have committed the crime without concrete evidence tying those individuals to the murders. Now, introducing testimony of evidence solely to the point to specific alternate suspects, unless it meets strict admissibility standards, right? Direct evidence linking another individual to the crime, as required basically under Idaho law. Instead, the defense would need to frame the unidentified DNA profiles as part of a broader strategy to undermine the prosecution's case, focusing on reasonable doubt rather than affirmative claims about other perpetrators. Frankly, I think it's a much better strategy. The court would likely restrict the scope of the arguments to ensure that they remain relevant to Kohberger's guilt or innocence, rather than veering into unsupported theories. The unidentified male DNA profiles are already part of the existing investigation, as they were collected and analyzed during the initial forensic examination of the crime scene. However, their use at trial would not go directly to the investigation in the sense of prompting new investigative action during the trial itself. So here's how it could potentially play out. Evidence is already in the record, right? The DNA profiles were documented by investigators and are part of the discovery process, meaning both the prosecution and the defense have access to them. Their existence is not new, and they have already been evaluated, for example, deemed ineligible for CODIS entry due to insufficient markers or other technical limitations, right? And if the defense raises questions about these profiles at trial, it could highlight investigative shortcomings, but this would not automatically trigger any kind of new investigation unless extraordinary circumstances arise, right? A new lead emerges from trial testimony, which is probably pretty unlikely. But if the defense successfully uses the unidentified DNA profiles to create reasonable doubt, leading to an acquittal or a hung jury, this could pressure law enforcement to revisit the investigation post-trial. For example, they might attempt to reanalyze the DNA with advanced forensic techniques or pursue new leads to identify the source of the profiles. However, during the trial, the focus is on adjudicating Bryan Kohberger's guilt or innocence, not to reopen the investigation. And any investigation implications would likely be deferred until after the trial's conclusion. Something else to consider, the fact that the DNA profiles were not eligible suggests limitations in their quality or their quantity, which may have restricted further investigation. Now, the defense could argue that investigators should have pursued alternate methods, for example, the genetic genealogy as used in steps to identify Bryan Kohberger, but this would be a trial argument, not a directive to reopen any case, obviously. And if new evidence related to these profiles emerged, a witness identified as potential source, the defense could file a motion to introduce it, but this would be subject to judicial approval and would not necessarily halt the trial. The defense's ability to leverage the unidentified DNA profile effectively depends on how they navigate the court's restrictions. So by focusing on the profile's existence to question the prosecution's case, rather than speculating about the alternate suspect, they can still use this evidence to their advantage, right? Let's give an example. The presence of multiple unidentified male DNA profiles at the scene suggests investigators were, incomplete. And the prosecution cannot conclusively prove Mr. Kohberger was the only individual involved, if he was involved at all, right? He is entitled to the presumption of innocence. And the prosecution's reliance on the single sample DNA from the night sheet ignores other DNA evidence that complicates the narrative of the lone perpetrator theory. Now, such arguments align with the goal of creating reasonable doubt while adhering to judicial limits on the alternate suspect claims. So, if the alternate suspect theory is disallowed, which I think it will be, the unidentified male DNA profiles can still be used to challenge the prosecution's narrative, questioning the thoroughness of the investigation and undermining the strength of the DNA evidence linking Kohberger to the crime. Now, the defense would focus on creating reasonable doubt by highlighting the gaps in the prosecution's case rather than directly implicating other perpetrators. This would, like I said, not go directly to an investigation during the trial as it's already part of the case record. And the trial's focus remains on Bryan Kohberger's guilt, and any investigative implications would obviously have to arise after the conclusion of the trial. So I know there's obviously two camps. Bryan Kohberger's guilty. I guess the middle is Bryan Kohberger has a presumption of innocence. And then obviously Bryan Kohberger is innocent camp. And it doesn't matter what evidence anyone's presented. But we try to look at the facts and the evidence here. And obviously we have had lots of conversation about the little DNA on the little snap right there, right? And the arguments that could possibly be made by the defense. We've talked about that for the last 2.5 years. But I wouldn't necessarily panic. I think the alternate suspect is a terrible theory that the defense is taking in the Kohberger matter. Use that unknown DNA simply as it goes to the investigation. It is relevant. It was found at the crime scene. That was, you collected it because it was something of evidentiary value. Correct crime scene investigator Smuckatelli? Yes, it was. And you tested it to see if it would, potentially leads. Yes, and for whatever reason you didn't. And maybe they didn't use the right technique to collect it, which could have led to additional clues, right? Those types of things. It goes to the investigation and the documentation of that evidence. And then obviously what steps did the investigators take to do it? Or did they just simply focus on Bryan Kohberger because obviously it was cleaner, simpler, and there's obviously a few more things that they could do. There you go. There's always a way. There's always a second way around it to get something into evidence. And worst case scenario, just ask the darn question and ring that bell in front of a jury. We'll see how it plays out. Next on the docket, the Karen Reed jurors are speaking out. All right. Obviously, the Karen Reed trial, the high-profile case centered on the death of Boston police officer John O'Keefe back in January of 2022, has drawn significant public attention, particularly the retrial's conclusion just the other day on June 18th, with Miss Reed's acquittal of second-degree murder and leaving the scene of the accident charges. But there was a guilty on driving under the influence, or operating under the influence, as they call it there in Boston. Now, the case has obviously been very polarizing, and it's amplified by a true crime enthusiast, and social media has led to several jurors publicly sharing their perspective post-trial. So let's take a look at the jurors' statements, the implications of their public disclosures, if any, and concerns about, I don't know, were they being truthful and honest or intellectually dishonest, or lapses in judgment, particularly regarding juror Paula Bratto's claim of being a true crime fan, where she actually followed Turtle Boy, but yet apparently to get on the jury, she said she was unaware of the case prior to her jury duty. It also respects the judicial process and acknowledges the prosecution's failure to prove the most serious charges beyond a reasonable doubt, right? Ultimately, at the end of the day, prosecution did not present overwhelming evidence as it related to guilt, at least to the jury in this particular case. That's the way the system works, ladies and gentlemen. Prosecution had not once, but two shots. They usually do better. I think they did better. Brennan was definitely a much better prosecutor, but the jury was not convinced. And the reality of it is these jurors come from the community. That's kind of what makes such a great process, is you get these people that come from the community, that are aware of what's going on in the community, right? But they also have to go back into the community, and they also have to be able to, for lack of a better term, justify what they did if asked. Now, nobody should hassle a juror or necessarily criticize the decision that they came to, because they came to it based upon the evidence or the lack thereof that was presented. But when they make some public statements, however, and you got to just kind of scratch your head, it makes you go, So anyway, multiple jurors have spoken out to media outlets after the retrial, offering their insights into the deliberations and views of the case. Now, juror number 11, Paula Prado, and another juror, Paula Sarah Gelden, have been prominent in their discussions. Their statements provide a little window into the jury's reasoning, but also raise some questions about their impartiality and the integrity of the deliberation process. So Paula Brado's statements, and a little bit about her background. Now, she is identifying herself as a true crime enthusiast on her X profile, claiming during jury selection that she had no prior knowledge of the Karen Reed case. And in post-trial interviews, Prado revealed that she initially leaned toward conviction for manslaughter, but shifted her stance as the trial progressed, ultimately believing O'Keefe's death occurred in the garage, aligning with the defense theory of a cover-up. She described the deliberation process as intense and noted that the complexity of sorting through evidence, particularly the verdict slip for the manslaughter charge, which jurors found very confusing. Despite her self-described passion for true crime, Prado's claim of ignorance about the case has sparked some skepticism. Posts on X question the plausibility of a true crime fan being completely unaware of this case that had obviously garnered lots of attention. And there's also some evidence floating around out there that perhaps she followed people, for example, the Free Karen Reed X profile, as well as this Turtle Boy guy as well. So does that mean somebody did something unethical to get on a jury? I don't know. Would it be the first time? I don't know. Anyway, jurors are supposed to attest to not having information about the first trial when they were selected on jury duty. It's somewhat implausible to believe that she didn't know of the case. Now, remember, it doesn't mean just because you don't, live under a rock that you have some knowledge of the case. That's okay. It's really whether you're able to set that information aside and judge the evidence based upon what is actually presented in court, not what you've heard from your buddy or what you read on your X post or you saw in a YouTube video. So just knowing about the case isn't necessarily an automatic disqualifier. And so obviously it goes to, Paula Sarah Gelden, who is a self-described true crime junkie. Like I said, she supposedly knew nothing about this case until she got to jury selection. Like I said, little hard to believe, but hey, we'll take them at their word, I guess, right? Anyway, these sentiments obviously are highlighting concerns about a little bit of intellectual dishonesty. As like I said, it seems a little improbable that an avid true crime follower would remain oblivious to a case that dominated headlines, podcasts, and online discussions for 3 years. Anyway, Paula Sodergren and other jurors also identified as true crime enthusiasts expressed post-trial that she felt Reed was completely innocent. Her active engagements with media outlets, very sympathetic to Reed's defense, has raised some eyebrows as well to some people, with critics suggesting that she may have sought attention by contacting the Free Karen Reed journalists. Now, Sarah Gelden's statements aligns with the defense narrative, emphasizing doubts about the prosecution's evidence, such as the lack of conclusive proof that Reed's SUV ever struck Mr. O'Keefe. Additionally, Ronald Estasleo, a juror from the first trial, spoke out in early 2025, revealing that the jury unanimously agreed to acquit Reed on second-degree murder and leaving the scene, but deadlocked on manslaughter. His disclosure underscored the jury's struggle with the manslaughter charge, a recurring theme in the retrial, where jurors obviously again found the verdict slip confusing. Now, reports indicate the jurors in the retrial were unanimous in acquittal Reed on the murder charge and the leaving the scene, but grappled with the OUI related to manslaughter charge. Questions sent to the judge during that corroborate that. So, and the judge during the deliberations, such as whether or not guilty verdict or the two charges, but a deadlocked on one of them constitute a hung jury, obviously suggested some uncertainty about the legal process. Now, jurors also sought clarification on whether Reed's media's interviews constituted evidence, indicating a need to navigate some complex evidentiary issues. Now, these questions reflect a conscious effort to understand the charge, but also highlight potential gaps in comprehension, possibly exacerbated by the case's technical and emotional complexity, I guess we could call it. Anyway, so the judicial process in the Karen Reed case functioned as it was intended, with jurors tasked with evaluating evidence against the standard of proof beyond a reasonable doubt. And the prosecution's case hinged on proving that Reed's intentionally struck O'Keefe with her SUV, supported by evidence like a broken taillight, the vehicle data, and the witness testimony claiming Reed said, "I hit him." However, the defense effectively sowed some doubt by highlighting investigative flaws, such as the failure to search the house where O'Keefe was found, allegations of police misconduct, and expert testimony questioning whether O'Keefe's injuries were even consistent with a car accident. The jury's acquittal, obviously, of the murder and leaving the scene of the crime reflect the prosecution's inability to meet the high burden of proof. Now, the guilty verdict on the OUI charge, resulting in 1-year probation, suggests jurors found sufficient evidence of Reed's intoxication at the time of offense, but not on the causation of O'Keefe's death. And this partial conviction indicates a nuanced deliberation process respecting the legal requirements to evaluate each charge independently. Now comes the concern of intellectual dishonesty. Now, while jurors are not expected to be legal experts, their role demands impartiality and critical thinking. Several aspects of the jury's conduct and statements raised some concerns about being a little intellectually dishonest or lapses in judgment. Prato's claims of ignorance, for example, she asserts that she knew nothing about the case despite her true crime interest. The Karen Reed case was obviously a media sensation with extensive coverage on platforms and true crime podcasts, and nearly 90% of the potential jurors in the retrial admitted prior knowledge, necessitating an expanded jury pool. And if Ms. Prado was untruthful during voir dire, this could undermine the impartiality critical to a fair trial, even if her claim is true. It suggests a lack of engagement with current events, potentially affecting her ability to contextualize the case. Then we have juror Sarah Gelden's post-trial outreach to media outlets aligned with Reed's supporters, suggesting a possible bias or desire for some sort of recognition. Her self-identification as a true crime junkie further fuels doubt about her impartiality, as a true crime media often sensationalizes narratives, potentially influencing perceptions. But what does it really mean at the end of the day? The jury's questions about the verdict slip and the evidence indicate confusion, particularly around the manslaughter charge and the lesser included offenses. While these questions reflect diligence, they also suggest a struggle to grasp legal nuances, which some critics have labeled as intellectual shortcomings. Obviously, the case's high-profile nature with vocal free Karen Reed supporters and conspiracy theories posed challenges potentially to jurors' impartiality. And the court implemented measures like the buffer zone and juror anonymity to shield the jury, but the intense public scrutiny may have indirectly influenced their deliberations, especially for jurors like Prado and Sarah Gelden, who later engaged with the case's media ecosystem. Anyway, the jurors' public statements highlight broader challenges in high-profile trials, particularly in the digital age, do they not? Social media amplifies case visibility, making it difficult to find impartial jurors. And the Karen Reed case, with its true crime allure and allegations of police corruption, obviously became a cultural phenomenon, complicating the voir dire process. Jurors like Prado and Sarah Gelden, with ties to true crime culture, exemplify the risk of preconceived notions infiltrating deliberations, even if subconsciously. Moreover, the jurors' disclosure post-trial may raise some ethical questions about their motivations. And while the Massachusetts jurors are not prohibited from speaking out, the trial jurors' handbook advises against revealing deliberation details or other jurors' votes. Prado and Sarah Gelden's willingness to discuss the case publicly, especially with outlets aligned with Reed's defense, suggests possible desire for validation or attention, which could obviously erode public trust in the jury system. Anyway, those public statements offer valuable insights into the deliberations, but also expose potential flaws in the jury selection and deliberation process. Despite true crime enthusiasts' claim of ignorance and media engagement by the jurors, questions whether there's intellectual honesty and impartiality. So while the jury acquitted Ms. Reed of the most serious charges, reflects a failure in the prosecution's failure to prove the case beyond a reasonable doubt, and I'm okay with that. That's the way the system works. But you really would like to make sure that you got true jurors. We've talked about this several times when there's been issues about jurors that write books, and what was the reason for they got on the case, or they didn't disclose that they were the victim of, for example, domestic violence. In the Scott Peterson case, like I said, when you get to voir dire, it means to speak the truth. It's a French word that means to speak the truth. And you have to be candid and you have to be open. And you can't hide there and say, oh, I think one side is, right or wrong, and not tell anybody. If you believe that, you should need to tell somebody before they get on the jury, because at the end of the day, you want a fair trial. And if it finds out, maybe they were biased or what have you, they should have told us that before the trial. Bottom line is, prosecution failed to prove their case. Whether you like the jurors speaking out or not, at the end of the day, I guess it really doesn't matter. It's done. It's done. It's over. And I've said this before. If you want justice, heading to the courthouse is not the place to go. There's always going to be somebody that's not pleased. Next on the docket, Sean Combs gets some good testimony for a change. So today, the federal sex trafficking and racketeering trial of Sean Diddy Combs continued in Manhattan with some significant testimony from the former assistant, Brendan Paul. Now, the key focus on today's events was Paul's testimony given under an immunity deal, which means anything that she said or anything that he said could not be used against him. So what took place? Well, there was testimony of non-coerced participation in freak-offs. That's right. Brendan Paul, the former assistant to Combs, testified that Combs' former girlfriend, referred to as Jane, testifying under a pseudonym, was a willing participant in these so-called freak-offs, or king nights, which were described as extended sexual performances involving Combs, Jane, and escorts. Paul stated that he had spoken with Jane after each event and had never heard anything suggesting that she was unwilling to participate. During cross-examination by Combs' attorneys, Paul was asked if he ever heard anything indicating Jane's lack of consent, to which he responded, absolutely not. The testimony was presented as a significant win, obviously, for the defense, as it countered the prosecution's claim that Combs used his fame, power, and violence to coerce women into participating in these events. The defense argues that the prosecution is attempting to criminalize consensual adult sexual activity, admitting Combs' involvement in domestic abuse, but denying the federal charges of sex trafficking and racketeering. As this case has gone on, I was expecting, frankly, a lot more than what we've received in this particular case. Now, does Sean Combs have some issues he may need to work through? Maybe a little bit of therapy? Yes, probably so. And when you're that rich and people are always there to beg you to be with them, to be part of your little group and party and all that good stuff, you start believing that you can do whatever you want and that everybody wants to do whatever they want. And I've also seen this before where everybody's all for it until they're not. And usually what changes in their mind is, well, the money stops, right? Combs gets rid of these people, and next thing you know, they're getting lawsuits and things of that nature. Now, I'm not condoning what Sean Combs is accused of doing. I mean, a lot of it's on video, is it? Right? The jury got to watch it. The question is going to be, is it criminal or is it just some rich dude getting his little freak off with consenting adults that were enjoying it until they weren't, which means when the money stopped and now they needed more money? I don't know. Obviously, I'm not a juror. And whatever the jury decides, we will respect that because that jury verdict would represent the jury's verdict as it relates to the charges. So we'll have to wait and see. But definitely it was a good day in court for Sean Combs today. They stopped early because one of the jurors had a child that was having a graduation of some kind. And so the testimony will resume next week. Next on the docket, another teacher goes down. That's right. In a quiet town of Elmira, New York, a scandal erupted that shook the community and tarnished the reputation of a local educational institution. Anna Marie Milazzo, a 22-year-old Greater Southern Tier Board of Cooperative Education Service employees, they shortened that to BOCES, found herself at the center of a criminal investigation that obviously brought a quick end to her teaching career and may alter her life forever. So on Monday, the Chemung County Sheriff's Office arrested Milazzo following a tip received by a school resource officer. The allegations were quite grave, and over the course of 3 months, Milazzo had allegedly sent lewd photographs to another 14-year-old boy at the school. The nature of their relationship remained unclear, as authorities did not disclose whether the boy was a student at the facility where she worked. The secrecy surrounding the minor's identity also and the specifics of Milazzo's role at the school only deepened the community's interest in the case. Anyway, Milazzo faces some serious charges, specifically second-degree dissemination of indecent material to a minor, a felony, and endangering the welfare of a child, a misdemeanor. Now, despite the severity of the felony charge, she was issued a ticket and released, with the court appearance scheduled later. Obviously, the decision to release her pending trial sparked murmurs of debate among various residents there, some of whom questioned the leniency, while others reserved judgment, awaiting for further details. Now, the Greater Southern Tier school district, eager to distance themselves from the whole scandal, confirmed that Milazzo's employment, but remained tight-lipped about her role and tenure. Swiftly, they terminated her employment, a move that did little to quell the public's curiosity or outrage. And whispers circulated through Elmira's coffee shops and school parking lots. How could somebody entrusted with shaping the young minds betray that trust so profoundly? What system had failed to allow such misconduct to persist undetected for months? And for the 14-year-old boy, the consequences were, well, a little less visible, but undoubtedly profound. Shielded by anonymity, he faced the daunting task of navigating the emotional and psychological fallout of the ordeal. Anyway, the community too grappled with its own question about trust, oversight, and safety to the children. Now, as Milazzo awaited her day in court, the story of her fall serves as a stark reminder of the fragility of the trust in institutions and the devastating impact of one individual's choice. There in Elmira, the echoes of the scandal linger, and a cautionary tale etched into the town's collective memory. Next, this day in legal history, on June 20th, 1832, South Carolina's nullification efforts against the federal tariffs escalated, prompting legal debates over states' rights, leading to the Force Bill of 1833 to enforce federal law. And on June 20th, 1863, West Virginia becomes the 35th state. While this isn't a crime, it's obviously law-related. And on June 20th, 1893, in New Bedford, Massachusetts, Lizzie Borden was found not guilty of the brutal axe murder of her stepmother and father. And on June 20th, 1943, race-related rioting began in Detroit, resulting in 34 deaths and federal troops intervening by Franklin Delano Roosevelt, highlighting obviously the racial tensions and the prompting of legal reforms. And do you mean a president ordered troops in to quiet protests? Yes. Funny how that works out. More things change, the more they stay the same, ladies and gentlemen. And on June 20th, 1967, boxer Muhammad Ali was convicted in Houston for violating selective service laws by refusing to be drafted. He was sentenced to 5 years in prison, overturned in 1971, sparking debates on free speech and, well, being a conscientious objector. And on June 20th, 1972, 3 days after the break-in at the Democratic National Committee headquarters in the Watergate complex, President Richard Nixon met with his chief of staff, H.R. Haldeman, in the Oval Office. This meeting was captured on Nixon's secret White House recording system, and it became infamous due to the 18 and a half minutes of missing tape, the gap in the audio, later discovered during the Watergate investigation. And we all know how that turned out. Next, the legal quote of the day has to do with juror misconduct. Juror misconduct is any misconduct that conflicts with the judge's instructions as to how jurors should perform their duties. Straightforward and simple. Got to follow the law, even if you don't like it, you don't understand it. Apply the facts to the law. That's what jurors are supposed to do. And then finally, our dumb criminal of the day. A Florida fugitive taunts the sheriff. Well, and he gets caught. So on June 17th, Aaron Donta Johnson, a 29-year-old wanted man from Florida, was arrested after brazenly mocking the Polk County Sheriff's Office and Sheriff Grady Judge through a series of social media posts. Now, Johnson, who violated a pretrial release condition, used Facebook to taunt law enforcement for their failure to apprehend him. In one poorly written post, Johnson bragged, "Y'all too busy fishing, that's why you didn't catch me when I left my grandma's house today. Should have waited a bit longer. You all accepted the challenge, right? Hashtag Grady can't find me. Hashtag come again, Grady." Now, the post, obviously riddled with grammatical errors and misspellings, were a direct jab at Sheriff Judge Judd and his team's effort. Undeterred, the Polk County Sheriff's Office confidently responded to the social media. "Spoken like a true man. Way to take responsibility for your actions," they wrote sarcastically. "No worries. We'll find you. Bet." Johnson continued his taunts, claiming, "I done outran y'all several times. Hashtag come try again, Grady." The sheriff's office fired back. Challenge accepted. The game of cat and mouse ended swiftly, and then on June 17th of 2025, guess what? The Lakeland Police Department and the Polk County Sheriff's Office apprehended Mr. Johnson. A photo shared by authorities showed the fugitive smiling alongside officers, marking the end of his ill-advised social media campaign. Now, Johnson's arrest serves as a reminder that taunting law enforcement online is a risky and foolish move, and Sheriff Judd and his team proved that no challenge is too big for bringing fugitives to justice. All right, ladies and gentlemen, that's all we have for you today. Thanks for joining us. Have a wonderful weekend. We'll see you next time. And remember, the Constitution matters.